Hey there, deep divers. Ready to dive into some California landlord tenant law?
Always ready to dive in.
We've got some fascinating material from Martinez Law Center today.
Oh, yeah? What have they got?
They handle both sides, landlord and tenant.
Interesting.
Should give us a pretty well-rounded look at it.
Yeah, no, for sure. That's a unique perspective.
Definitely. So if you're renting out there or own property or just curious about your rights in California, this one's for you.
You know, it's amazing how many disputes we see
Oh, yeah.
could be avoided with a little bit of communication and planning ahead, really.
So before we get into legal stuff, it sounds like prevention is really key here.
No, absolutely.
What are some of those common issues that you see popping up again and again? The ones that kind of lead to these big landlord-tenant showdowns?
You've got two people, often with different priorities, sharing a space.
Right.
We're bound to have some friction there. But some of the big ones, though, definitely property maintenance.
Okay.
Leaky faucets, broken appliances, those sorts of things. Pest infestations, especially. If those aren't addressed quickly, those can really blow up.
Right, because if you're the tenant and you're dealing with those things, it affects your daily life, your sense of well-being in your own home.
Right. And then you've got the rent disagreements.
Oh, yeah.
Rent increases, late fees, all that. Payment schedules, yeah.
Those can get messy.
Oh, those can get very heated. And of course, we can't forget security deposits, always a favorite.
It seems like security deposits are always a minefield.
Ugh.
I feel like everyone I know has a security deposit horror story.
It happens more often than you'd think.
Really?
Yeah, and it often boils down to misunderstandings or just not enough documentation.
Okay.
Like a landlord might try to deduct for something that was just normal wear and tear.
Okay.
Or a tenant might not understand what they are actually responsible for fixing.
So again, sounds like it all comes back to communication.
Yeah.
Or miscommunication and that ounce of prevention.
Absolutely. If landlords and tenants just talked more, and really set expectations early on, addressed issues right away, documented things, I think we'd see a lot fewer of these cases ending up in court.
Okay, so let's say I'm a landlord.
Right.
What are my big responsibilities under the law in California?
The number one thing is you have to provide a habitable property.
Okay.
This means it meets basic safety and health standards.
Got it.
So things like working plumbing, heating, electricity, no major structural damage,
Basically making sure it's a safe and livable place.
Exactly. And this isn't just good practice, it's the law. California has something called the implied warranty of habitability.
Okay.
So even if it isn't spelled out in the lease, you are required to provide a rental unit that meets those basic standards.
So it's not just about what's in writing.
Right.
There are these underlying legal protections for tenants.
Exactly. Now, beyond habitability, you also have a responsibility to follow the right legal procedures, especially when it comes to evictions. In California, you can't just kick somebody out because you feel like it.
Right.
There's a very specific process.
Right.
It starts with a written notice.
Okay, I've heard about these 3-day notices.
Oh, yeah.
What's the deal with those?
Powerful tools, but they have to be used the right way. A 3-day notice is a legal document. It gives a tenant 3 days to fix a lease violation.
Okay.
Like not paying rent, or they have to leave the property.
Right.
But there are specific rules. If a landlord messes up that process, the eviction might not hold up.
So it's not just a get-out-of-jail-free card.
Not at all. And that's where good documentation comes in. Landlords should really thoroughly document the property's condition before a tenant moves in.
Oh, okay.
Pictures, a detailed checklist, the whole 9 yards.
So if there's a dispute later,
You can prove what the property looked like before.
like taking before pictures before you renovate.
Exactly. You're setting a baseline.
That makes sense.
This is crucial for those security deposit disputes, too.
Oh, right.
You can clearly show what was already damaged
Got it.
versus what might have happened during their tenancy.
Okay. Landlords, take note. Documentation is your friend.
It really is.
Now let's flip the script and talk about the tenant side of things. So I'm renting a place in California. What kind of legal protection do I have?
Well, like we said, you have that right to a habitable place.
Right.
If there are issues that affect your health or safety, you can demand repairs.
Okay.
And if the landlord ignores those requests, you have legal options.
Like what kind of options?
Sometimes you can withhold rent until the repairs are made.
Oh, wow. Okay.
Or you can even sue the landlord to force them to do those repairs.
So you do have some power.
You absolutely do.
Right.
And as we mentioned earlier, tenants have strong protections against illegal evictions.
Okay.
A landlord can't just change the locks or turn off the utilities without going through the right steps.
Right.
That's what's called a self-help eviction, and that's illegal in California.
So no more landlord horror stories about getting locked out.
Hopefully not. And if that happens, you can sue them for damages and potentially get your tenancy back.
Wow, that's really good to know. I think a lot of renters just assume they're at the mercy of their landlord. But it sounds like in California, that's not really the case.
Not at all. The law provides a lot of protection for tenants. But just knowing your rights isn't enough.
Right.
You have to know how to actually enforce those rights. And that can be tricky.
Yeah, so it's not just about knowing the rules, it's about knowing how to use them.
Exactly.
So what are some strategies that tenants can use to protect themselves?
The number one thing, document everything. Keep records of your communication with the landlord, take pictures of any damage or needed repairs, and keep copies of your important documents.
Okay.
Things like your lease agreement and rent receipts. That documentation can be super important if a dispute comes up.
Right, because it's your word against theirs.
Exactly. And if you do find yourself in a dispute, don't be afraid to get legal help. A lawyer who knows landlord-tenant law can help you understand your rights, see how strong your case is, and guide you through the whole process.
Like having a guide in a really complex legal landscape.
That's a great way to put it. Because even if you know your rights, the legal system can be intimidating.
Right.
Having a lawyer by your side can make a huge difference.
This has been so informative.
That's a lot to take in, I know.
We've covered the basics of landlord and tenant responsibilities, and it's clear that communication and documentation are key for both sides.
Absolutely. Those are the foundations of any good landlord-tenant relationship. But even when everyone's trying their best, disputes can happen. And when they do, it's important to know what your options are.
Okay, so let's talk about what happens when those disagreements hit a boiling point. What are some of the paths forward when we're talking about resolving landlord-tenant disputes?
All right, let's get into it. Well, the good news is it doesn't always have to be a courtroom drama,
Yeah.
There are ways to resolve things without going to court.
That's good to hear.
Often these other ways are faster, cheaper, and less adversarial.
I'm all for that. Tell me more about these alternative ways to resolve things.
One option is what's called ADR.
ADR.
Yeah, it stands for Alternative Dispute Resolution. Basically, it's a bunch of different methods you can use to resolve disputes without going through the traditional court system.
ADR. I've heard that term before, but I'm not really sure what it all entails.
Sure, yeah.
What are some of the specific ADR methods that might be helpful in landlord-to-tenant disputes?
Well, the simplest one is just negotiation.
Just talking it out.
Exactly. The landlord and tenant communicate directly, try to find a solution that works for both of them. Maybe there's just a misunderstanding about the lease, or maybe one side's willing to compromise a little on a rent payment. Often a conversation is all it takes to smooth things over.
That makes sense, but sometimes those conversations can get a little heated.
Oh, yeah.
Especially when emotions are running high. Is there a way to have those conversations in a more productive way? Maybe a little more structure?
That's where mediation comes in. It's basically negotiation, but you have a neutral third party there, a mediator helping to keep things on track.
So they're like a referee.
More like a facilitator, really.
Yeah.
They help both sides listen to each other, understand the other's point of view, and hopefully come to an agreement they both can live with. The mediator doesn't make any decisions, though. Their role is just to guide the conversation and help the parties find their own solution.
That sounds helpful, especially when things are tense. It's like having someone there to de-escalate the situation and help everyone find that common ground.
Precisely. And mediation can be really effective. Studies show it has a pretty high success rate in settling all kinds of disputes, including those between landlords and tenants.
Okay, so we've got negotiation and mediation. What other ADR options are there?
Another option is arbitration. It's more formal than mediation, kind of like a mini trial, but it happens outside of the court system. Both sides present their case to a neutral arbitrator, and then that arbitrator makes a decision to resolve the dispute.
So it's a little more like having a judge, but without all the formality of a courtroom.
Yeah, that's a good way to put it. And depending on what the parties agreed to beforehand, the arbitrator's decision may be binding, which means both sides have to follow it.
Interesting. So it sounds like ADR has a pretty good range of options, from casual conversations to more structured processes.
It does.
But when does it make sense to go the ADR route, and when is it better to just head straight to court?
ADR can be a great option in many cases, especially when both parties are willing to work things out and avoid the time, expense, and stress of a court case. But it isn't always the right approach.
When would you say it's not the right approach?
Well, if one of the parties is being totally unreasonable or refusing to budge, ADR probably won't get you very far.
Makes sense.
Or if the legal issues are really complex, it might be better to have a judge make a decision.
Okay.
And of course, if there are any safety concerns or if there's a possibility of violence, you should always put safety first and get law enforcement involved.
Right. ADR is about compromise, not about forcing someone into an agreement they're not okay with.
Exactly. It's important to remember that ADR is a voluntary process. Both parties have to agree to participate, and either one can walk away at any time if they feel like it's not working.
Okay, so let's say I'm a tenant and I get an eviction notice. What are some things I can do to protect myself?
First things first, read that eviction notice very carefully. Make sure you understand why you're being evicted and what the deadlines are. Don't ignore it.
Right. Ignoring a legal problem rarely makes it go away.
Never does. Now, if you think the eviction isn't fair or if there are special circumstances, try talking to your landlord.
Okay.
Explain your situation and see if you can work things out without going to court. You might be surprised how often a simple conversation can clear things up.
So even in the middle of a possible eviction, communication is still key.
It really is. But what if you talk to your landlord and they just won't budge? What then?
Yeah. What are your options at that point?
Well, that's when you might want to talk to a lawyer. They can help you figure out your rights, see if you have a good case, and potentially challenge the eviction in court.
That's where having that legal expertise can be really valuable.
Absolutely. And remember, you have rights all throughout the eviction process.
Okay.
The landlord can't cut corners. They have to follow the law exactly. If they make even a small mistake, the whole eviction could be thrown out.
So just because you got an eviction notice doesn't mean it's a done deal. There's still things you can do.
Exactly. It's all about knowing what your rights are and taking action right away.
You know, it's interesting to me how much Martinez Law Center seems to emphasize these alternative approaches,
Yeah.
even though they're totally capable of handling those big courtroom battles.
I think it shows their dedication to finding the best solution for each client you know,
Yeah.
whether that's through negotiation, mediation, or if absolutely necessary litigation.
It's not about winning at all costs. It's about finding a solution that's fair and that works.
Right, and sometimes that means helping clients understand that compromise can be the best way to get a lasting resolution.
That's a great point. It's easy to get caught up in the battle, but sometimes the most effective approach is to take a step back and find some common ground.
And a good lawyer can help with that. They can give you unbiased advice, explain all the legal stuff, and help you make informed decisions.
Okay, so we've talked about preventing these situations, and we've talked about different ways to resolve disputes. But what about those things people might not know? Those aha moments you know.
Oh.
What are some things about California landlord tenant law that might surprise our listeners?
Oh, I like this part. Let's talk about security deposits.
Okay.
Did you know that landlords in California can't just use the security deposit for anything they want? There are specific rules about what they can take out of it.
Wait, really? So if there's some wear and tear on the property, the landlord can't just deduct that from my deposit?
Nope. Normal wear and tear is just considered part of the cost of doing business for a landlord. They can only deduct for damages that go beyond normal wear and tear. So if they try to take money out for faded paint or carpet that's a little worn, you can challenge that.
Wow, that's good to know. I bet a lot of people don't realize that.
Probably not. It's one of those little known things in the law that can really help tenants.
Okay, hit me with another one. What else might surprise our listeners?
How about this? Did you know that in California, landlords have to follow specific rules about entering a tenant's rental unit? They can't just come in whenever they want.
Seriously. So even though they own the property, they can't just pop in unannounced?
Nope. Unless it's an emergency, they have to give you proper notice.
Wow, so tenants actually have legal protection when it comes to privacy and that right to quiet enjoyment of their home.
Absolutely. And those are just a couple of examples. There's a lot more to California landlord tenant law than people might realize. That's why it's always smart to do your research, know your rights, and talk to a lawyer if you're not sure about something.
This is why these deep dives are so great. We're uncovering these hidden gems that can help people navigate these tricky situations.
Exactly. Knowledge is power, especially when it comes to your home.
Speaking of knowledge and empowerment, we've been talking a lot about the tenant side of things.
Right.
But what about landlords? They have rights and responsibilities too, don't they?
Oh, of course. Landlord tenant law is all about balancing the rights and responsibilities of both sides.
Right.
Landlords have a right to get paid on time, to enforce the terms of the lease, and to make sure their property isn't damaged.
So it's a two-way street.
Exactly.
What are some key things landlords should keep in mind to make sure they're following the law and protecting themselves?
Well, like we've been talking about, good documentation is essential. Landlords should keep detailed records of everything from the condition of the property when the tenant moves in, to any communications with the tenant, to rent payments and repair requests.
So that paper trail is important for landlords too.
Just as important. It can protect them if a dispute arises, and it helps to make sure they're doing things fairly and openly.
Okay, so beyond documentation,
Yeah.
what other advice would you give to landlords, especially those who are new to this?
I'd say the most important thing is to educate yourself about California landlord tenant law. There's tons of information online, and you can always talk to a lawyer who specializes in this area.
So don't just wing it. Do your homework and know the rules of the game.
Exactly. And remember, communication is just as important for landlords as it is for tenants. Be proactive, address problems right away, respond to requests, and keep your tenants informed.
So it's about building a good relationship, not just treating tenants like walking wallets.
Exactly. That kind of approach can really go a long way toward preventing those disputes in the first place and making the rental experience more positive for everyone.
This has been incredibly informative.
It has.
We've covered so much, from those common causes of disputes to different ways to resolve them, to those little-known facts about California landlord-tenant law. I feel like I've learned a ton.
Me too. Hopefully our listeners feel more confident and prepared to handle their own rental situations now.
Speaking of our listeners, I have a feeling some of them might be wondering about those situations where ADR just isn't going to cut it.
Right.
Those cases where things escalate and end up in court. Can you give us an idea of what that process looks like?
Sure, let's dive into the world of eviction lawsuits in California. Okay, so we're talking eviction lawsuits in California.
Right, that final frontier.
Definitely a topic you hope you never have to deal with, but it's smart to understand how it works, just in case.
So let's break it down. What are the main steps involved in an eviction lawsuit here in California?
Well, it starts with that notice we talked about, the 3-day notice or whatever notice is required.
Right, the landlord's official heads up.
Yeah, gives the tenant a chance to fix the problem or move out.
If the tenant doesn't comply with that notice, then what?
Then the landlord can file an unlawful detainer lawsuit in court.
Unlawful detainer, that sounds serious.
It is. It's the legal term for an eviction lawsuit in California.
Okay, so the lawsuit's filed. What happens next?
The tenant gets served with a copy of the lawsuit, and they have a limited time to respond, usually 5 days.
So you can't just ignore it?
No, definitely not. If you ignore the lawsuit, the landlord could get a default judgment.
What does that mean?
It means they automatically win the case, and the tenant gets evicted.
Yikes. So what should a tenant do if they get served with an eviction lawsuit?
The most important thing is get legal advice right away. A lawyer can explain your rights, help you figure out how strong your case is, and figure out what to do.
Because I imagine there are different ways to respond to the lawsuit depending on the situation.
Exactly. You might file an answer where you deny what the landlord is saying in the lawsuit.
Okay.
Or you might be able to raise certain defenses.
Defenses? Like what kind of defenses?
Oh, there are a few different ones. A
Yeah.
common one is that the landlord didn't follow the proper procedures. You know,
No.
like maybe they didn't give you enough notice, or they didn't serve the lawsuit the right way.
So even a small technical mistake on the landlord's part could stop the whole eviction process.
Yeah, it's possible. That's why it's so important to have a lawyer look over everything and make sure the landlord did everything by the book.
I'm starting to see why having a lawyer is so important in these situations.
It really can be a game changer.
Yeah.
Now, if the case can't be settled through negotiation or some other way, it'll probably end up going to trial.
Landlord versus tenant in court. That sounds intense.
It can be. Both sides present their evidence and witnesses and make their arguments in front of a judge.
And the judge decides who wins.
Right. The judge will look at the evidence, listen to the arguments, and consider the laws, and then make a decision.
Okay, let's say the judge sides with the tenant. What happens then?
That's a win for the tenant. The eviction is stopped, and they can stay in their home.
That's a huge relief, I bet.
Absolutely. But what if the judge sides with the landlord?
Well, that's probably not good news for the tenant.
Unfortunately not. It means the tenant has to move out, usually pretty quickly.
So that's it for their time in that place.
Yeah. And it's important to remember an eviction can have lasting effects.
How so?
It can make it harder to rent in the future, and it can even hurt your credit score.
This is why it's so important to understand your rights and take those steps we talked about earlier to protect yourself.
Absolutely. It's also a good reminder that these legal battles can be really tough on everyone involved.
So it's best to avoid them, if at all possible.
For sure. And that comes back to good communication, thorough documentation, and a clear understanding of the law.
It's all about fostering respect and collaboration between landlords and tenants right from the start.
Exactly. If you can do that, you have a much better chance of preventing those disagreements from turning into major legal battles.
Wow. This has been a fascinating journey through California landlord tenant law.
It has.
We've covered a lot, and I think our listeners are leaving today with a lot of helpful information to navigate their own rental experiences.
I agree. Remember, knowledge is power. Stay informed, know your rights, and don't be afraid to get legal advice if you need it.
And if you're in California and looking for legal guidance, Martinez Law Center is a great resource.
They are.
They have a team of experienced lawyers who specialize in landlord tenant law, and they have that unique perspective because they represent both sides.
They're really committed to finding those fair and practical solutions for their clients.
We're deep divers. We've reached the surface of our exploration into California landlord tenant law. We've covered a lot, but remember, this is just the beginning. Keep learning, keep asking questions, and keep standing up for your rights.
And as always, stay curious, stay informed, and keep diving deeper into the world around you.
Until next time, deep divers.
Call now 714-442-9741. Thank you.